Considerations of what constitutes a good faith or bad faith effort often have to take into account a specific request to preclude use of an effort in derivative litigation because part of the charges involve abuse of the judicial process in using legal filing efforts connected to other kinds of redress for derivative acts. If, in fact, in the body of the request, the claim, there is a specific request for preclusion for use in derivative action, and it is instead used for derivative action. And it is not only demonstrably used in derivative action, but it has also failed to provide a justification for so doing. Then there becomes a risk that the derivative actions in which it has been used have actually transcended the jurisdiction of the court involved, specifically because the court was disabusing its powers and was disabusing a process that was explicit in order to assume duties or actions that it could be able to engage in jurisdictions that it was not allowed to. I'm going to read directly, cite from Federal Magistrate Program. The Federal Magistrate Program provides a means of enforcing discipline on base with respect to civilian criminal misconduct. The availability of the program depends on the location and jurisdiction of the base, the type and locale of the offense, and the status of the offender. How magistrate court works. Federal magistrate court is an alternative to prosecution in federal district court. Magistrate court generally provides a more expeditious and cost-effective forum than federal district court for minor civilian criminal misconduct. Military members on Title X orders should not be prosecuted for criminal offenses in federal magistrate court. Prosecution in federal magistrate court requires the consent of the defendant. Federal magistrate judges normally try misdemeanor offenses for which the authorized penalty does not exceed 1 year of imprisonment. Criminal actions committed by civilians on military installation may be handled in a federal court contingent upon the jurisdictional status of the installation and whether the crime in question violated state or federal law. This is from a manual, The Military Commander and the Law, a manual that is put out by the Judge Advocate General School aboard Maxwell Air Force Base in Alabama. If you are going to send me a response with the kind of case law citations you did, and you are not going to definitively identify a justification for so doing, and you're going to include a footnote identifying a special order exception, then I'm letting you know that I consider that to be an act of war. I consider you to be a foreign occupier in my country, and I'm going to treat it as such until further notice. If you have decided to make me a defendant, I absolutely do not consent to a magistrate court. If you understand that what I was requesting was a new trial to bring criminal charges, including criminal charges that are actionable under the nation's anti-terrorist laws, and including criminal charges for simulation of military process and simulation of legal process, as well as attempts to make civilians accomplice witnesses to crimes under the jurisdiction of the Military Code of Justice, then I'm going to treat you as if you are a foreign occupier in my country who has refused to provide a means to due process and has refused to provide a legal system and a legal means by which you are going to engage me as a prisoner of war. It is 10:39 a.m. on June 9th, 2020.